Hello, and welcome to Connected with Latham, where we discuss ideas, legal developments, and business trends shaping the global economy. I am Nicole Liffrig Molife, counsel in the Healthcare and Life Sciences practice in our Washington, D.C. office. I advise on healthcare regulatory considerations that arise in healthcare transactions, specifically mergers and acquisitions for strategic and private equity investors. Today's topic on healthcare transaction oversight is an important issue for companies looking to invest in healthcare provider and service companies, including practice management companies. Joining me today to share their insights are Yanyan Zhou, counsel in our Los Angeles office, and Margaret Rote, associate in our Washington, D.C. office.
Thanks, Nicole. I'm looking forward to discussing these state developments with you today. I work closely with companies on obtaining regulatory approvals, whether or not those approvals are related to state certificate of need and licensing requirements, or under the state healthcare services transaction review laws. Margaret, I'm so happy you joined us today as well to share your thoughts.
Thanks, Yanyan. I'm excited to be here today with you and Nicole and to talk about these new state laws that can result in extended review and approval timeframes for healthcare provider transactions. Analyzing the impact of these laws is an important step that we handle in our mergers and acquisitions in the healthcare sector.
Thank you both for joining the podcast today. We are discussing the increased level of state regulatory oversight of healthcare services transactions. States continue to expand their review of transactions involving private equity, real estate investment trusts, management services organizations, and other investors in healthcare companies. Many of these state laws look beyond traditional mergers and acquisitions to include any material transaction. These types of transactions include minority ownership changes, sale and leaseback arrangements, joint ventures, debt lending arrangements, and other collaborations and commercial affiliations. Over 10 states have adopted or proposed transaction review laws. Margaret, I know that we saw a number of new developments this year. What states enacted or expanded their healthcare transaction review laws in 2025?
We've been monitoring these laws for several years, and 2025 was another big year for state-level oversight of healthcare deals. 5 states enacted new laws or expanded existing laws. Starting with the East Coast, both Massachusetts and Maine rolled out new updates. Massachusetts enacted updates that broadened the Massachusetts Health Policy Commission's material change review, require disclosures around significant equity investors, and even restrict REIT leasing of Maine hospital campuses. Maine went further with a 1-year moratorium on private equity and REIT ownership, operational control or financial control of in-state hospitals. Indiana expanded reporting and monitoring with new requirements around reporting controlling interests and stronger Attorney General investigative tools. New Mexico stood up a comprehensive regime to review hospital and provider transactions explicitly reaching MSOs. Yanyan, there were also some significant changes in California, correct?
Yes, that's right, Margaret. As you know, California's healthcare transaction law went into effect on April 1st, 2024. It requires certain healthcare transactions to be reported and reviewed by the Office of Healthcare Affordability, also known as OCA. However, in late 2025, the law was expanded to also include transactions involving private equity groups, hedge funds, and MSOs. The law was amended to include a new category of reporting entities called noticing entities. If a company falls within this new category, they must provide notice of certain transactions to OCA, although in more limited circumstances than what's already required for healthcare entities. Specifically, the types of companies that fall into this new category of noticing entities include hedge funds, private equity funds, MSOs, new business entities created for the purpose of entering into agreements or transactions with a healthcare entity, and entities that own, operate, or control a healthcare provider, regardless of whether the provider is currently providing services or has an active license.
Thanks, Yanyan, for that summary. When did this new California law go into effect?
Nicole, This new noticing entity requirement went into effect on January 1, 2026, of course, assuming that the applicable revenue threshold is satisfied and the healthcare entity or MSO is undergoing a material change, which includes a change of control. OCA has stated that it will enact regulations to implement this new law by spring of 2026, which will have additional information about what needs to be included in these notices. But at this time, the expectation is that written notice is provided to the agency in accordance with the statute.
Thanks, Yanyan. That is definitely an important law for investors looking to buy companies in California, given its broad reach. The types of transactions impacted by the California law in other states have grown, affecting a number of transactions and investors that are commonplace in the healthcare sector. Margaret, do you see this trend continuing in 2026?
Nicole, we saw state laws expressly encompass transactions involving venture capital, private equity, and other equity investors. In many cases, the legislative history frequently cited policy interests related to private equity, high leverage structures, and ownership and control of healthcare providers. Reflecting this shift, many laws and proposed rules are starting to clarify and to define key terms such as private equity and venture capital, to reduce ambiguity and to identify the common types of buyers that the states assert fall within the scope of these transaction review laws. We saw this in several states, including Massachusetts, Indiana, and California, and we expect this trend to continue in 2026.
I agree with you, Margaret. We also saw a similar trend with states having an increased focus on REITs and sale-leaseback arrangements, particularly in Maine and Massachusetts. Beyond these states, there were also legislative efforts made in other states that were ultimately not enacted, but would have prohibited REIT transactions with hospitals or required REITs to take certain actions in the event of hospital financial distress. Although not all of these bills were enacted, we anticipate renewed legislative efforts ahead in connection with REITs, and that is another area we will continue to monitor in 2026.
Thanks, Yanyan. These state healthcare review laws certainly cover a range of healthcare services and provider companies, including hospitals, physicians, and other healthcare entities and providers. Yanyan, I know the type of providers subject to these laws can vary from state to state, but what are the common types of companies and providers subject to these state laws?
Yes, we agree. There's a lot of other healthcare providers that can be covered under the scope of these laws. Most commonly, I would say that I see physician organizations like ACOs and IPAs, and we will oftentimes see other types of licensed healthcare facilities in addition to hospitals, such as skilled nursing facilities. The one thing that I haven't seen yet under these laws is veterinary health.
Thanks, Yanyan. Given the scope of the laws vary by state, it's important for companies to carefully review the definitions of healthcare providers and entities under these laws. We saw last year around 10 states introduce legislation to impose notification and other review requirements on healthcare transactions. Investors should definitely continue to monitor for new and renewed efforts seeking broad mandates. In addition to the expanded category of transactions subject to these laws, we also saw the regulatory criteria and process continue to evolve last year. Margaret, what areas are under review?
These regulatory reviews focus on anti-competitive behavior and potential negative impacts to access, quality, cost, and equity of healthcare. The reviews often demand more expansive disclosure regarding investment ownership and financial information. In some cases, the information is shared publicly in public forums or government databases. In addition, these laws often mandate or encourage coordination with other state agencies about pending transactions, even authorizing attorneys general to investigate transactions in some instances. Yanyan, what are you seeing in terms of regulatory guidance and review times?
Last year, because states need to react in real time to pending transactions, we are definitely seeing more states provide guidance via public websites rather than using formal regulatory notice and comment rulemaking processes. Generally speaking, the state regulatory review timeframes can be quite extended, up to 3 to 6 months in some cases.
These evolving review processes and disclosure requirements can potentially lengthen timeframes and raise deal execution challenges for investors, healthcare entities, and other stakeholders. Margaret, are there any key takeaways or action items for investors looking to purchase healthcare companies this year?
As investors are considering deal timelines, it's going to be key to be mindful of long review periods. Companies should also consider how to allocate risk in transaction documents. We see this manifest as transactions that have extended interim periods between signing and closing. This may include having covenants requiring cooperation among the parties to prepare and submit the filings, and requiring material consents or approvals as closing conditions.
These state filings are a critical discussion point on transactions and often are made into closing conditions. As always, it will be incredibly helpful to have early healthcare regulatory and antitrust engagement to assess any required filings, the timeline, and to coordinate on the approach. The types of targets and transactions subject to these laws vary from state to state. Given that so many of these laws are new, early engagement is important in case guidance needs to be obtained from the state regulatory agencies on whether the transaction is subject to those requirements. If so, the parties need to work collaboratively to prepare for the submissions, especially given the enhanced financial, operational, and ownership disclosure information that needs to be submitted to the agencies under these transaction review laws.
All great points, Yanyan. These laws definitely affect how parties allocate the costs and risks of the review, and parties need to consider how these longer regulatory processes may impact financing and deal execution. Understanding the scope of these laws and how they impact transactions is important for both companies looking to sell or exit an investment, as well as new investors and buyers. As we have discussed, these state laws have cast a broad net in terms of the types of transactions and healthcare entities subject to these laws. In addition, the thresholds, including the transaction size, number of providers, and volume of in-state or out-of-state revenue that trigger review is relatively low. Given these laws can apply to a range of provider types as well as businesses with a small footprint in a state, Margaret, what are some key areas to diligence early on?
Understanding a company's organizational structure, the range of healthcare providers, and the scope of the company's operations in each state, as well as the state-level revenue, is critical and should be a high-priority work stream. Also, companies should monitor developments in the states where they operate, as these laws have had very short implementation windows once they're enacted. Yanyan, with that in mind, what do you think companies and investors should monitor this year?
We are expecting this regulatory landscape to continue to expand over the course of 2026. Additional states might enact these types of laws, and states with legislative efforts that have previously failed may try to renew their efforts to pass the legislation. We also expect that state agencies will continue to issue guidance, which will further inform how these laws should be interpreted and applied.
Thanks, Yanyan. Staying on top of evolving guidance and review processes in states with existing laws or states that may adopt new laws is a critical item for companies in 2026. And I think this nicely wraps up our podcast. Thank you to Margaret and Yanyan for joining today and sharing their insights and impressions on this important healthcare transaction topic.
Thank you for having me on the podcast, Nicole.
It was a pleasure to be here today. Thank you, Nicole.
If you are interested in learning more about state healthcare transaction review laws, check out our client alert that we published. This will be available in the show description. And thank you to our listeners for checking out our Connected with Latham podcast. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Spotify, or anywhere else you listen to podcasts. If you have questions or would like additional information, please email us using the links located in the show description. We hope you will join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.